Ghanatube so your mom official pa Yadamasipon said just a money 8 me at na fee Nimunina just a moon giant Merry Christmas to all our lovely everywhere and some eye coso and the Epa Wakana Hamunim say dear the Bremona Mate Namu Christmas season but news need is a drop here and Munjin to say Ghanatube for the Brem now Mashe Mammitia a committee you want to say many stories in Airborne Medin Amagisua and a year Michelle young quite negotiation some I cost so any the Epa Ewo.
Yes, you make the point and let's see if it will help us locate.
Okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even found ours on the 16th. On the 16th of December, this Mandamus application was filed on the 17th. But my Lord chose to hear the Mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same. Okay. Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. Now, my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes, absolutely.
You see, some of the facts being heard on this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context. The process he found.
You can read.
No, just hold on.
Please. What he found was not before the judge. It was not before the judge.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, he came to court holding the documents.
No, we're talking about the second application. Or the first application, the one they filed on 6.
The one they filed.
The first application. Okay. So, Mr. Tamaklo,
yes.
Continue.
So, my Lord, at the time my Lord considered, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the Mandamus application, he now asked me to call.
And for any for some I cost any the eba or manimuna or so egusu out with and Ghanatube is one and say the same no way say you plus a deepest one so we did tell of here and the bird bro now who now what now I share the air cost any the eba ever or minimum and some no ebisu as was so say.
Oh, okay. So he had it.
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it and started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared during the Mandamus. He knew that that would definitely affect their rights. My Lord, on the grounds of bias, my Lord, the point we make here is that at the time, with respect, my Lord was considering the Mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he is done hearing, our application for judicial review would have become moot. Manifest bias. Malak 2. The Mandamus application, in one breath, my Lord says our gender on page 2. Offense under 20 rule 14 of CI 47. However, my lords, the Mandamus application that was granted, with respect, had no statement of case attached. So in one breath, my Lord was holding us to the strict compliance of the rule, but in the other breath, waive it for the interested party. My Lord, without the statement of case, the court's jurisdiction for the Mandamus was not properly even invoked. And so the orders founded on it were definitely done in excess of the court's powers or its jurisdiction. We submit.
What is your authority for saying that?
Mark 65 rule 6. 2.
It says what?
6.2. The court may, on the hearing of an application for judicial review, then 2, within 14 days after the filing of the notice of application, the applicant shall file such copies of the applicant's statement of case. And my lords, this court, in the case of Nitete Ahinkwa II and Thomas Okai, civil appeal number J4 2009, dated 29th April 2010. His Lordship Justice Badegbe has this to say, that when J4/20/2009, it was dated 29th April 2010. It says, quote, where the rules of court prescribe a particular mode of seeking relief, then a failure to initiate the proceeding for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Now, in excess of jurisdiction, specific. In the case of Francis Owusu-Mensah and another, versus National Board for Professional and Technical Examination, civil appeal number J4 1/57/2017, dated 1st May 2018. It was held.
Council 57 or 67?
57. Eniegwa JSC, as it then was, had this to say: a court may have jurisdiction to entertain a cause or matter, but the procedure invoking its jurisdiction may deny the court's jurisdiction. In this case, the court, the High Court, has the jurisdiction to entertain a Mandamus application, but the rule says at the hearing, a statement of case must be attached to the application. That is how the court jurisdiction is invoked.
Mr. Tamaklu,
My Lord.
even in this court, your colleague raised a fundamental issue, preliminary objection, which we have waived.
Oh, my Lord, I take it that you are willing to waive this one.
And we said that, look,
my Lord, when you waived, it was on record as having waived it.
so it's
In this case, my Lord, the ruling of my Lord is before you. The court never said they are waiving that non-compliance. My Lord, the court never said that. It is a different thing if the court, in exercising its powers, gave an indication on record that it is waiving that non-compliance. That was not done. My Lord, it's a court of record. My Lord,
does it matter to you that the other side did not file an affidavit in opposition? Does it matter to you?
yes, my Lord.
That the EC before the High Court was not opposed to the application?
My Lord,
Therefore, the waiver even started with the EC.
No, my Lord, the waiver is not one that the party should raise, with the greatest respect. It's not one that requires that a party should raise an objection to the non-compliance.
The party may raise it.
Yes, I'm saying that without that, this court is required to consider it.
For her and now, just a run requirement with fair, a one some apostle, any the eba, a war a year, than a ham semester pass a Christmas is in show who see if you say a lovely viewers in Yamu, Pine, must say someone yatena all year round. Ha, a Ghanatube, so Michelle, and now from the Sadia, minimum 18 cry.